Hi, I'm Sarah Everhart, and I'm a legal specialist with the Agricultural Law Education Initiative, and this is a video about premises liability. Picture with me for a second a group of children decides to take a walk across your pasture to a nearby pond without your permission. Unfortunately, one of the children in the group steps into a hole and breaks her leg. Now her parents are threatening to sue you for the injuries. What's the extent of your liability, and are you at fault? Premises liability is the body of law which makes a person who is in possession of land liable for certain injuries suffered by persons who are present on the premises. It's important to note that premises liability is applicable to the person in possession of the land, not necessarily the person who owns the land. This means that a farm tenant could also be liable under the theory of premises liability. The answer to what is your liability all depends on what is your duty of care to the person who's on the property. Your duty of care or your legal obligation is going to depend on various criteria, such as why were the people on your property and what was the extent of your knowledge that the people were on your property. You owe a duty of care to visitors depending on the classification of that person. Maryland has 3 classifications of visitors: trespassers, licensees, and invitees. And the classification of licensee is broken down into bare licensees and licensees by invitation. Let's walk through these 3 different classifications and go over their various duties of care. The first classification that we'll talk about is that of a trespasser. This is the lowest level duty of care that a person will have. A trespasser is a person, as we all know, who enters your land without your consent and remains there. This includes children. Some states differentiate between children and adults, and there's different levels. In Maryland, children are treated the same as adults. If they're trespassing, they're trespassing. An example of this in the agricultural context is, let's say Charlie's riding his ATV on your neighbor's farm and decides, despite a clear no trespassing sign, to continue riding his ATV onto your property, and then is injured. What is your duty of care to Charlie at this point? He's obviously a trespasser, so your only duty of care to him is to refrain from causing willful or wanton injury. What does that mean? Well, willful or wanton injury is a very high standard. That means that you would actually have to try to injure Charlie. You would actually have to create a situation that you were purposely injuring him in order to breach your duty of care. Obviously, this would depend on the facts of each situation, but an example of a willful or wanton injury would be if you knew that ATV riders repeatedly crossed your property, and so in order to stop this, you strung an unmarked cable across the trail, hoping that the ATV riders would ride into this string and then injure themselves. This is an example of a willful or wanton injury that you would cause, and this would be a breach of your duty of care to a trespasser. By contrast, if you set up a clearly visible fence across the trail or erected another no trespassing sign that would be clearly visible to anyone trespassing, you would not be found liable if the rider still managed to injure themselves by crashing into the fence, for example. The next classification that we're going to talk about is that of a licensee. A licensee is someone who has consent to be on your property. Licensees are broken down into 2 different categories, the first of which being a bare licensee. A bare licensee is an individual who has permission to be on your property, but is really there for their own purpose. A bare licensee has to take your property as he finds it. This duty of care to a bare licensee is similar to that of a trespasser. You don't owe any duty to this particular person, except you can't willfully or wantonly injure them or entrap them, create some situation where they would get hurt. An example is if you allow a neighbor to hunt on your property for no charge. He's not there as a social guest, but you just allow him to enter onto your property. A licensee by invitation is a social guest you invite onto your property, such as a guest at a party. In this situation, you have a higher duty of care. You must take the care of a licensee by invitation that you would take of a member of your own family. You have to take reasonable care of this person and make the premises safe for them to be there. You need to warn them of dangerous conditions at the property that cannot be reasonably discovered. For example, if there was a patch of ice on your property that was hard to see unless you were walking right upon it, you would need to warn this person that this was an icy area and they should take care. It's interesting to note that a licensee can become a trespasser by going outside of the bounds of their invitation. For example, if you invite neighbors over to your property to fish at a small pond, and then you leave the interaction with your neighbor to go get some bait, for example, and the neighbor, without your permission, goes and enters into an old barn structure on your property and gets injured while in the barn. That person has gone from a licensee who had the permission to be at the pond fishing into the barn as a trespasser. So your duty of care has now been reduced. The final classification is that of an invitee. An invitee is a person who's invited onto your property for economic benefit, such as a customer to a U-Pick operation or an agritourism operation. This is the highest level duty of care that you have as a landowner or someone in possession of land. The duty is to protect the invitee from unreasonable risks and to keep the property reasonably safe. So this means you have the duty to regularly inspect the property before the invitees are present at the property. You have to warn the invitees of danger, and if you know of any dangerous conditions before the invitees arrive, you need to remedy these dangerous conditions. How does liability occur? It's not an automatic thing. In order for liability to occur, an injured person must either file a claim with the farmer's insurance company or initiate civil litigation. In order to be successful in civil litigation, the injured party has to prove that there was negligence on the part of the farmer. Negligence is proved by first proving the duty of care that the farmer owed, that the farmer breached this duty of care, and that the injury was related to that breach of the duty of care. Of course, the farmer may present defenses to the allegation of negligence, and that I will go over in a separate video. Thank you.